everyone. It is our absolute honor to welcome you all to the concluding lecture of the Chief Justice MC Chagla Memorial Lecture Series 2025, organized by the Students' Council of Government Law College Mumbai. As you all may know by now, as it is our concluding lecture, that this series has long been a platform for engaging with some of the finest minds of our legal fraternity. And because this is our concluding lecture and we have been through 4 very successful lectures yet, I would like to once again extend my heartfelt gratitude to Justice Riaz Chagla and the MC Chagla Memorial Trust for all their support, and I'm very grateful to them for the same. I would also like to extend my thanks to our principal, Dr. Asmita Vaidya ma'am, for her guidance and her support. And of course, my heartfelt gratitude to Advocate Amit Jamsandekar sir, so that he accepted our invitation to attend this lecture. I now request our professor in charge, Kavita ma'am, to kindly felicitate sir.
I would like to briefly introduce our respected principal, Ma'am Dr. Asmita Vaidya, who unfortunately could not be in attendance today. Ma'am is a skilled administrator, educationist, and has been honored with many awards like the Tejaswini Award, the Nation Builder Award, and the Superwoman Award 2020. She joined Government Law College as our principal, and since then has introduced several activities and programs in our college, and has been a chief resource person on different legal topics including cyber law, intellectual property law, human rights, and time management. She has organized several national and state level conferences, seminars, short-term training programs, and workshops. We thank her for her continued guidance and support.
I now request our professor in charge, Dr. Kavita ma'am, to kindly introduce us her.
Respected guest on dais, Advocate Amit Jamsandekar sir, my dear colleagues and dear students, a warm good morning to one and all. Today, we are here to gain knowledge on intellectual property right, which presents a dynamic and growing field for advocates and cover copyright, patent and trade secrets law. Trademark is one of the areas of IPR. Trademark can be called as a brand identifier, represents a company and product. The mark and the identifier can give exclusive right to use it only when it is registered under Trademark Act. Registered trademark mark enables company to prevent others from using similar mark that would cause confusion. Trademarks are valuable assets for the business. Today, we have with us Advocate Amit Jamsandekar to throw light on such significant topic. Advocate Amit is alumni of our college, is practicing at Bombay High Court since year 1998. He is also a solicitor of the Supreme Court of England and Wales since 2002. Sir completed his Master in Law from Cardiff University, UK in year 2001 and currently pursuing PhD from the University of Leicester, UK. He is a leading commercial litigation counsel in IPR and has litigated cases in India covering trademark, patent, copyright, arbitration, and commercial laws. He represented Indian as well as international clients from several businesses like pharmaceuticals, packed food, packed goods, media, sports, software, defense, banking, financial services, cement and steel industries. As a leading IPR practitioner, in India he has selected by United States Department of USA for prestigious International Visitor Leading Program in 2008 and was also nominated by the Embassy of USA for L World Fellowship. He has contributed in academic field also and has been an adjunct faculty at IIM Bangalore, Creative Future School as well as Institute for Intellectual Property Studies at Mumbai and also worked as a research associate for Cardiff Law School, UK. He has contributed his research articles in European IP review and communication law and also acted as a referee to the Journal of IPR. So we have privilege of welcoming truly remarkable speaker to the stage, So we are eager to hear you on this important topic on the journey of trademark law in India. I again welcome sir and request Advocate Amit Jamsandekar to take up the stage and address gathering. Unfortunately, our sound system is not working due to heavy load of yesterday's program. So it's temporary arrangement we are making. We regret for the inconvenience caused.
Thank you very much for the introduction. And I believe I have 45 minutes to cover up the topic. In a broad term, intellectual property, there are various laws and mainly, sorry, it's working. All right. So, within the term intellectual property, there are broadly 4 laws which covers this field. First is patent, second is copyright, third is trademark, and fourth we generally, it's not a codified law, but the confidential information which is governed by the common law. That is the 4th field. Of course, there are new laws such as geographical indications, semiconductor, and the other aspects which also falls within the term intellectual property. But mainly the 4, these are identified as intellectual property laws. Now the term intellectual property is a young term to describe these laws. When these laws were evolving, there was no such term like intellectual property. It was known as industrial property. And this is not very old, because when I did masters, the module which covered intellectual property, that module was termed as industrial property even in 2001. So we are talking about hardly 25 years back, how the intellectual property term evolved, and then the industrial property phased out. When we say that it's intellectual property, there is a reason why it's intellectual property. Because we are dealing with an asset which is not tangible. It's an intangible asset which is subject matter of these laws. Now, does it really require intellect to acquire that asset, the exclusivity or property, whatever you call it? I think it may not, because of course, when I say it does not require intellect, it requires some kind of sense. That sense has to be so strong, and the ability to identify that sense, to convert it in the property. A fine example is that when these laws were evolving, we started from patenting it, because when the United States of America was getting organized, and when they were writing their constitution, because the USA is the country of immigrants, they wanted to invite people who are skilled. They have some kind of skill with them, so that when they migrate to the USA, the country will benefit from their skill. So that was the broad vision of the legislators in the USA. Within their constitution, they made a provision. It's a hardly 2-page constitution of the United States of America, and within the constitution, they made a provision to protect patents. The reason was that they considered that this is going to be the asset which can be exploited worldwide, first in America and then by way of export in the other countries. That was the time when they recognized patents by special statutes and started granting patents for a limited period. One example how that patent system worked and why I said that it may not be, you may not require intellect really to get that asset, is that a young student was sitting in a pub and he was playing with one chord. He was winding it and all of a sudden he formed one combination, and that combination became a paperclip, what we call is U-clip. We use it to club the papers. That was subject matter of the patent, and that student really gained millions by exploiting that patent. That patent survived for almost 25 years. The U-clip which he introduced in the market, the length of second end of that was very short. So while pulling out, it used to damage the papers. There was another guy who thought that no, if we increase this length, then there won't be any damage to the paper. And that was one inventive step that second inventor took, and that was subject matter of second patent. So when I said that you may not really require intellect, but you should have a sense to ensure that there is something new, there is some, either it's an invention or inventive step which you can identify and then explore. So that's the reason it subsequently around after 80s it started developing the trade, and the legal profession started leaning towards the phrase intellectual property, and the industrial property phase. Now, as I said, within this broad term there are 4 acts. Trademark is one of them. There are few laws such as trademark which have developed accidentally. The reason they developed accidentally is this. In 1600 in England, there was no such law which recognized trademark. In fact, there were guilds, and those guilds had regulations. These regulations were meant to punish the labor who worked on that particular article. So these marks were used to identify the particular person who manufactured that article. And then guild regulations punished him if in case of any defect in the manufacture. So these were not really property marks, but these were liability marks. Slowly, these liability marks were used in the shipping industry to identify the goods of shipper. Again, from liability, it shifted towards identification mark. There was no such right which was recognized so as to enforce that right in a legal framework which existed. Around 1615 in England, trade was growing and people started using some kind of identification on their goods. On the clothes, on pottery or other articles, there was some kind of identification which conveyed that this particular item is sourced from particular manufacturer, or it's identified or selected by a particular person and sold in a particular shop. So that identification became so popular that traders started recognizing some kind of right in that, but there was no law. There was not a single judgment as such which recognized this kind of right. But there was problem because a popular mark was copied by another trader, and therefore there was some kind of deception in the market. Now, how to tackle that deception? in absence of any legal framework. Of course, there was no statute. For example, for patent there was statute of monopoly. For copyright there was statute of Anne, which were operating in the field. But for trademark there was nothing. One trader, he really took a chance. He went to the court, not court of equity, but common law court, without knowing that he can't approach the common law court because there was no property. Common law court required title. Court of equity required title so as to grant injunction. Common law court, he had to go there with some kind of right. But the common law court did not have jurisdiction to grant injunction. That court recognized, the judge realized that there is some problem and how to tackle it. The judge recognized that there is some kind of right and there is a deception happening in the market. Consumers are deceived, and therefore there has to be some kind of protection to this trader. Injunction was not granted, but right was recognized. On the basis of that right, subsequent actions followed. There were claims made in the common law in respect of trademark. Of course, the injunction was not granted again because there was no title to the mark. Slowly, around 1613, the claims were made in the court of equity, and court of equity realized that there has to be some kind of right now which will have to be recognized, right in the nature of property. That proprietary right was recognized first by judgment called Southern versus Howe. Southern versus Howe recognized that right, and though expressly the judgment did not record that trademark is a property, but somehow it was inferred that it's a property and therefore injunction will have to be granted. Now that was the judgment which governed the field for many years, and towards 1659 the law of trademark started developing. In 1813, another judgment which was delivered in England by the Court of Equity on the basis of Southern versus Howe, recognizing trademark as a property. That's, if you open any book like Curley or any Indian commentary on trademark, you will find that Millington versus Fox is considered as the first trademark judgment. Now Millington versus Fox is considered as first judgment on trademark. The reason is that that's the judgment which said that fraud is not the essential element of trademark action, because prior to that, all the law which developed, it was developed on three terms. One, fraud; second, misrepresentation; and third is the equitable angle of it for grant of injunction. Deception, misrepresentation and fraud, these three words coupled with the principle of equity govern the law. Now these three words originated from the contract law, because these three words, they did not have any place because there was no law first of all, and when the law was evolving, there had to be some backup. So these three words were imported from the contract law and then they were placed within the legal jurisprudence of trademark. Millington versus Fox is the first judgment which said that no, deception is there, should be there, misrepresentation should be there, but fraud is not the essential requirement of trademark action. And that's the reason the Millington versus Fox, this is the judgment which is considered as the first judgment. Technically it's not the first judgment, Southern versus Howe is the first judgment, which is of 1680. What is interesting is that when I said that the trademark law is developed by accident, in the judgment, the Lord Chancellor Cottonham, when he wrote the judgment, there is not a single word in his judgment where he has said that trademark is a property. But the case note, the gentleman, the reporter, court reporter, who wrote the case note of that judgment in the report, he wrote one word that the judgment considers trademark as property. He wrote it in a background that during the trial, the defendant said that I am not liable to pay damages. I recognize the plaintiff's trademark. In fact, when the cease and desist notice was given, the reply was sent by the defendant's solicitor stating that I did not know that it's a property of the plaintiff. That word was chosen by the reporter because that is the fact which was stated by Lord Chancellor Tottenham in his judgment, that this is the defense of the defendant. So the court reporter picked up that word and in the case note placed it as if Lord Chancellor Tottenham has held that trademark is a property. That judgment was cited subsequently in many cases, and the court started recognizing that trademark is a property. So this was the accident which happened and the reason why trademark became property. Now this proprietary nature and trademark is a property, the whole concept continued for 100 years, more than 100 years. And then some judges realized that there is something wrong in this. How did it originate? So they traced back to Wellington versus Fox. Of course, not a single judge said that the court reporter made a mistake, but they corrected it. They said that if we recognize this kind of monopoly where there are no limits, there is no time limit and there are no limits as such, there are no boundaries fixed to this kind of property, and if we recognize such kind of property, then it may be something more than the patent, something more than the copyright, which should not be, because it will be monopoly in the words, it will be monopoly in the graphical representations. So they said no, this is not a property, but it's a right in exclusivity. So the trader uses the mark, and by such use he acquires exclusivity in the use. And of course, then there was a problem. If it's not a property, then where is the court's jurisdiction? Because the court of equity could not grant jurisdiction in absence of proprietary rights. So again, that position was molded that yes, it's not a property. It's the exclusive right which the traders acquire by virtue of using the mark in commerce. And that exclusivity is the property. And that's how court acquired jurisdiction, court of equity acquired jurisdiction. And then the law developed on that basis. There was no codified law. Of course, the trade grew, there was industrial revolution in England, in Europe. More and more articles were introduced in the market and it required some kind of protection. Of course, there were lobbies working in England, and these lobbies started pushing the legislators to introduce codified trademark law. The first demand was that there has to be some kind of registration system. And the reason was that the law which was developed up to 1838 was the common law. The common law came to be identified because one judge expressed this kind of action as passing off. And the passing off word was picked up by other judges in subsequent judgments, and that action in common law came to be identified as passing off. Sometimes judges said palming off, passing off, but afterwards the word passing off really became popular, and that even today we call it passing off. So that passing off law developed. When the traders had to approach the court of equity for an injunction, what they had to do? They had to go with a bulky evidence that they are using it, the defendant is using it, there is a deception, the marks are similar. It was very voluminous evidence, and because the right is in personam, not in rem, if they successfully sue one defendant and some other defendants start using the similar mark, they had to go and chase that defendant with same kind of evidence, the same injunction application trial, and it used to be very expensive. That was the reason the trade demanded that no, there has to be some kind of registration system, there has to be some register. While making that demand, the trade also demanded that trademark should be recognized as a property. The reason was that by that time, patent was a property, not the patent as such, but the article which was manufactured by employing the patent was considered as property. The copyright was property not because the copyright in the text, but when it was printed, the book was a property. So the trade was under the impression that this is something is property. Of course, by that time, greedy traders, they wanted to ensure that there is some kind of asset with them. And if this is some kind of asset which they could achieve, they were really happy. So the bills which were sent by many guilds for consideration to the parliamentary committee, one such bill also contained a provision that trademark should be property. Of course, select committee was appointed, and after that committee was appointed, all these bills were considered by the select committee and the evidence was recorded. When the evidence was recorded in 1860, there was very popular solicitor in London. His name is Travers Smith. And Travers Smith had a roaring practice for trademark actions. Very popular solicitor. So he, being the leading practitioners in London dealing with trademarks matter, he was invited by the select committee to depose before the select committee on the text of the act which was proposed. And question was posed that in one bill, there were three bills which the select committee was considering, and in one bill he was asked by the select committee that this is the provision by which the traders are claiming that mark has to be a property. And his opinion was sought. In 1860 he deposed that if we recognize trademark as a property, it would be a fraud with statutory sanction. Because the reason of this deposition was that the trademark came to be recognized as a right, exclusive right, and that exclusive right as a property to ensure that the public interest is protected. It was not meant to protect the trader. It was not meant to protect the trader's goodwill. The whole exercise which was done by the courts, where at various stages the judgments were molded and the right boundaries of the rights were fixed. The reason was that to ensure that the consumer is protected. By this jurisprudence which was developed to protect the consumer, indirectly the trader was protected and he could gather that right, he could acquire that asset, not in the mark but in the goodwill which generated by using the mark. So goodwill was the property, trademark was not the property. This was the common law situation. Now that they wanted to reflect, the trade wanted to reflect that property in the goodwill in the text of the act, the first attempt failed. So in 1862, the law was introduced in England and the registration system evolved. The first act did not really contain any provision for registering the trademark. The provisions were made to organize and govern this field by way of penal provisions. There was no civil remedy provided. This law was in place for almost 12 years. And then the next act, which is Trademarks Registration Act 1875, was introduced. And this is the first act which really contained provision for registration of the mark. Formal trademark registry was introduced in England, and of course then there were procedural aspect, and trademark for the first time became some kind of right which can be on the register like patent. And from there the law developed. At no point of time since 1862 until 1994 in England, the trademark rights did not go beyond the core concept, that is indication of origin and connection in the course of trade. Now, indication of origin is the primary function of trademark. Why its primary function? Because the whole right in the trademark and the principle of trademark law, it exists only to protect the consumer. What it does, that when a trader puts his mark on a vendable article and puts that article in commerce, the consumer identifies the article with that source by using the medium which is the mark. Therefore, it is the primary function of the mark is that to ensure the link is established between the manufacturer and the consumer. So the consumer identifies this mark is used by a particular trader. He manufactures goods of a particular quality. I like those goods or I don't like those goods. The medium is the mark. Therefore, the function of the mark is to indicate the origin, source. And the connection in the course of trade is this, that when the mark performs its function of indication of origin, it forms a connection between the manufacturer and the consumer. Once that connection is formed, the function of the mark is fulfilled. So that is second criteria. So all the provisions of all these acts from 1862 to 1994 were linked to this core function, and the law developed in England. Now up to 1940, we did not have codified law in England, in India. The law which was developed, passing off the common law, that was implemented in India as it is, without any change, because we were common law countries. We are common law countries. And therefore that common law was implemented to protect, because same thing was what was happening in England, same thing was happening in India also. Because there was confusion, there was deception in market, because there were traders who were copying somebody else's mark. There was need of that kind of protection in India. But what was experienced in England, that court of equity really had to struggle to recognize that right for granting injunction, and therefore exclusivity was considered as property. In 1877, when the Specific Relief Act was introduced in India, section 54 of that act contained a provision that to grant an injunction, the source of jurisdiction or power is the Specific Relief Act. So that's the act which gave power to the court in equity to grant an injunction. That act contained a provision in section 54 that for the purpose of granting injunction, means for the purpose of section 54, trademark is a property. So what was experienced in London and how the courts in England came out of that problem, that was taken care of section 54 of 1877 Specific Relief Act in India, and that was the act which was used to protect traders or the consumers from the infringers, and that act operated up to 1940 in India. Up to 1940, there was no legislation in India. First act came in 1940. In fact, the former Registrar of Trademark, Mr. Venkateshwaran, who wrote his book in 1938 on trademark law. That's the first edition of his book, when there was no law. And of course, he advocated that this is what has happened in England, and we should overcome that problem, and we should have the modern trademark law in India. And that's how in 1940 the law was introduced in India, which was exact replica of 1938 UK Act. Because by 1938 in the UK, trademark law was well developed. All boundaries of trademark rights were settled. the rights were recognized. It went to the extent that it became a right which could be assigned, it became a right which could be licensed, of course with many limitations and restrictions, but that kind of right and that kind of sub-rights were recognized by 1938 Act. And the reason these rights were recognized by 1938 Act is that there was a committee formed in 1936 in England, which was headed by Lord Goshen, it's called Goshen Committee. Goshen Committee submitted a report in which the recommendations were given by the Goshen Committee that trade has grown now. We are a matured economy and consumers are matured. So there is no harm in recognizing that trademark could be assigned, trademark can be subject matter of licensing arrangement, and so on and so on. So the trademark regime was really liberalized by the Goshen Committee. Goshen Committee was of the opinion that now it is universally accepted that it's a proprietary right. And by taking recommendations from Goshen Committee, 1938 Act was introduced in England. 1948 Act was the replica of 1938 Act, and in India we followed exactly the same principle. Whatever was said in England was replicated in India, including the judgments, and there was nothing wrong in that because the text of the act was identical. That act remained in force until 1958 Act, when 1958 Act Trade and Merchandises Act was introduced in India. Fundamentally there were no changes, and we again aligned with 1938 Act with few modifications here and there in the text, but not in the jurisprudence. 1958 Act governed its field until 1999 Act, which it came to be introduced in India and was implemented from 2001. Now here there is a problem. From 1862 up to 1999, we followed the British law as it is, no change. Every judgment was followed in India, and there was a reason, of course. The text was similar, jurisprudence was similar, there was nothing wrong to follow that. And it is not only India, but the other common law countries like Australia, New Zealand, Canada, in the United States of America, the judgments which were delivered in the UK since 1600 were followed really in its true spirit and sense. In 94, the situation changed in England. What happened in 94 is that the European law was developing, and there was European directive which was in force. The United Kingdom was bound by the European Union directive on trademarks. After the TRIPS, member states were under the obligation to align and harmonize their trademark, their intellectual property laws, which included trademark, which TRIPS provides a broad outline what the law should be. Provisions of TRIPS and other provisions form part of EU directive, which became binding on the United Kingdom. And they had a time limit to implement that European directive. That European directive was implemented in 94 by introducing Trademarks Act 1994 in the UK. The fundamentals of trademarks completely changed. The reason is that what was known for centuries, what the trademark is, that becomes so liberalized that from the definition of trademark, the crucial terms like indication of origin and connection in the course of trade were removed. It's only a sign. That sign can be anything. Anything which can be graphically represented. That's the definition of mark which is contained in 1994 Trademark Act. Of course, this was to ensure that there is compliance of EU directive, there is compliance of TRIPS, but it became so liberalized with a special provision that it's a property. That law was something new even to the legal practitioners and judges in the UK, because they never considered that the trademark will be stretched to this extent, to the extent that it is not a trademark which was recognized for centuries. It is some kind of right in which you can deal. And the reason the judges and legal practitioners were struggling, because after 1938, though it was considered because of Gaussian Committee that the trademark regime is completely liberalized, the courts did not really accept that position. In fact, around 80s, when the House of Lords were dealing with the provisions of licensing and arrangement, there's a very famous judgment called Holly-Hobbes. Holly-Hobbes judgment, they were dealing with licensing and assignment provisions and the fact that how can a trademark be a subject matter of transactions, such as if a trademark is being used in respect of particular goods, for example, pharmaceutical goods which can be subject matter of class 5 within the classification. If one trader is using in respect of pharmaceutical goods, he is entitled for a registration in respect of pharmaceutical goods in class 5. What if he goes from class 1 to class 45 in all the classes without any intention to use the mark in commerce? And what he does, he uses in respect of pharmaceutical goods, but he deals in the mark by way of his registration. He gives license to third parties to manufacture books. He gives license for manufacturing other instruments, and that's how he trades in the market. That trading was going on, and that was the issue before the House of Lords. The House of Lords considered the entire jurisprudence which was developed since 1600 and particularly after Millington versus Fox, and said that this is not something for which the rights in the trademarks are recognized. They in fact term it as this kind of acts would be naked licensing. That's the term which was used by the House of Lords, naked licensing. And they said that no, this pin, and the another term which was used is pin to piano registrations. So they go in all classes and keep trading in those marks. They sell it, they give license, and other transactions were done through the registrations. So by Holly-Hobbes judgments, the House of Lords said no, this is not the purpose, this is not the intention behind the legislation, and they curtail all those attempts made by the traders. And that was the reason, because these judgments were the fundamentals of trademark law, and that was the notion which was developed in the minds of legal practitioners and judges. So this 94 Act was a bit of a shock for the entire profession, and they were struggling to deal with that kind of extended protection, and the judges were not readily accepting that position and the liberal interpretation. I am giving 2-3 incidents. What happened after? I have 10 minutes. Sorry. What happened after 1994 Act in the United Kingdom? The Chancery Division was headed by Justice Hugh Laddie. He had the assignment of IP. First infringement case came before him in 94, and that the marks were Wagamama versus Raja Mama. Wagamama was it's still a very famous Japanese restaurant in London, and they have a great reputation in London. One Indian entity, they started restaurant with the name Raja Mama in London in close vicinity. The claim was made by Wagamama that mark is similar by virtue of Section 10 of 1994 Act, which grants very wide and extended protection. There need not be any confusion. And Without that confusion, Wagamama claimed that it amounts to infringement of the mark. Apart from other issues, Justice Laddie was a bit concerned with this liberal interpretation, so wide interpretation, because the law was that A, there has to be a mark, B, somebody else should use a mark which is deceptively similar to A's mark, and there has to be likelihood of confusion and deception. There was no requirement to prove any confusion and deception. What was the requirement of proof and degree of proof was that the plaintiff should be in a position to prove likelihood of confusion and deception. Now that likelihood of confusion and deception is not the requirement under the new regime of 1994 Act. That was the claim made by the plaintiff. While dealing with this claim, the submissions were made on behalf of the plaintiff that the 94 Act originates because of EU directive, and EU directive is taken from the Benelux law, because prior to EU directive, Benelux, Belgium, Netherlands and Luxembourg, these three countries had a different kind of trademark regime since 1980, very liberalized regime. According to Benelux countries, while the EU directive was under negotiation, the Council's minutes which were recorded, the Benelux countries pushed their law in the EU directive. And therefore, it was argued that the source of EU directive is Benelux law, which is a very liberalized trademark regime. And therefore, the interpretation of 1994 Act has to be aligned along with the Benelux law. So it becomes so wide that the fine example is given of Benelux regime is that the claimant's mark was monopoly and the defendant was using anti-monopoly in respect of same goods. Benelux court said that no, it amounts to infringement. There may not be any confusion and deception. In fact, there can't be any confusion and deception. But the law and the jurisprudence which Benelux countries recognize is that the plaintiff has a right irrespective of confusion and deception. Therefore, injunction was granted. So the claim was made by the councils of Wagamama that is something which the Trademark Act of 1994 in the UK should recognize. Of course, this was rejected on the ground that it will travel beyond the core function of trademark, the primary function of trademark, that is indication of origin, and law should not recognize anything which is beyond this function. Otherwise, it will cease to be a trademark, it will become a property right. And the whole purpose that the law is meant to protect the consumers, and indirectly the trader is given that kind of incentive to ensure that there is no confusion and deception in the market. Everything will be haywire, and that's why that claim was rejected. Now the second provision which was introduced in the Act, you may have noticed earlier there were no comparative advertisement. For example, there were no advertisement that Samsung X amount, LG X amount, VU X amount. There were no such advertisement. 1994 Act recognized that kind of advertisement, provided there is no dilution of the mark, no derogatory treatment is given to the mark, etc., etc. And it's the trade practice which recognizes that kind of use. There were advertisement immediately published by many traders giving comparison of the prices. For example, TV, Samsung TV, 100 rupees, LG, 120, XYZ, 200, and they used to say that this is the comparison, we are the best. That is what is comparative advertisement is. Immediately after introduction of 1994 Act, which contained the provision for comparative advertisement, there is a very popular airline, low cost airline in UK and Europe, Ryanair. Ryanair published one advertisement outside Heathrow Airport saying that Ryanair XYZ, Lufthansa XYZ, something else XYZ, and there was at the bottom of that list was expensive BA ... Everybody understood what is that. So expensive BA means British Airways, which was the most expensive airlines for that sector, and the ticket price was given. So the description was that Ryanair, Lufthansa, Emirates, then BA ... expensive BAs. So the of course the meaning was expensive bastards. That was the meaning which was given to that advertisement, and that was the claim made by British Airways before the Chancery Division. Again, it came before Justice Hugh Laddie, who had the assignment of IP, and he said that yes, there is something wrong, but not wrong to the extent that it amounts to injury. So that's how judges really molded the law to ensure that it does not travel beyond the core functions, primary function of trademark indication of origin. Now, of course, on that line now, UK trademark law has developed up to now after 2025, and they have not departed from the core functions. Now, after the Brexit, hopefully they will go back to the British approach, because in between what happened that they were governed by the European Court of Justice decisions, because UK Supreme Court, not the House of Lords is the Supreme Court, they did not really have jurisdiction to interpret the provisions of the European directive. So for the purpose of interpretation, they had to frame a reference question and make a reference to the European Court of Justice, and that reference used to be answered, and that was the law for the purpose of UK jurisdiction. Now after Brexit, of course, they are not bound by the ECJ decisions, but whatever has happened since 1994 up to the Brexit, that may have some binding effect or great persuasive value for interpretation of the 1994 Act. Now this is the problem when it comes to India. We followed British law as it is, British and Commonwealth countries law. 1999 Act to a large extent is a replica of the 94 Act. When I say large extent, but the crucial aspect like indication of origin, connection in the course of trade, these provisions are written as it is, which were the provisions under 1938 UK Act and 1958 Indian Act. So we have written that portion, the core fundamentals are as it is. Now the question arises, which interpretation and which judgment should we follow? Should we follow Benelux law? Should we follow ECJ law? Should we follow the UK law, which has taken conservative approach even after the implementation of EU directive? That is something which is yet to be decided in India. But yes, 1999 Act, which is in force in India, adopts many concepts from TRIPS, adopts many concepts from the UK 1994 Act without realizing that the UK 94 Act originates from EU directive. We try to make our law distinctive by itself. I would say successfully we have done it. The question which remain to be answered is that which is the law which will influence further interpretation of our law, and that is yet to be decided by our courts. But the tendency is that many judges, High Court judges, are following OHIM, that is Office of Internal Harmonization of European Trademark Law. OHIM registers decisions. There are decisions you will find which are cited from UK, which are cited from other countries, European countries. There are decisions of ECJ which are reflecting in our judgments, but there has to be a caution. which we have to take, because we are not really even close to the UK Act, which was historically the case, and therefore there has to be some kind of caution which we have to take to regulate and ensure that the proper interpretation of our act is done. Thank you so much. It was a great pleasure to be here, and I'm coming to GLC almost after 29 years.
No one can able to trace like that whether it is copyrighted or truly created by the AI. So how do you envision that after the AI there will be some shift in the jurisprudence?
There will be some kind of shift, but see, the intellectual property laws are meant for humans.
Okay.
The AI generated work, for example, when we say AI generated work, it will be generated by machines. There won't be human brain behind it. Now, if we take one example of copyright law, the software is recognized as a literary work in the Copyright Act. But that software is made by humans. Now there will be software which will be generated, the coding will be done by the AI. Now currently there is no provision in the Act to recognize that directly. Possibly there can be interpretation that it will fall within the definition of literary work, because I gave command, I did it, it's my AI, I developed the AI, so the human brain is mine. Possibly there can be a possible interpretation, but it is far-fetched. To govern the AI field, I am sure the laws will be amended to ensure that some kind of protection is given or the protection is curtailed. What will be done, we don't know, but there will be some kind of legislation which will govern the field. Currently there is nothing. So if we go back, forget about AI. 7-8 years back there was one case. A very popular photographer was traveling in Thailand, and he was having a coffee and his camera was on the coffee table. One monkey came and he clicked one photo. The question was, who is the owner of copyright in the photo? So same, if we draw the analogy, it will be the same situation. Anything else?
Can I speak in Marathi or English?
Yes, please.
मराठीमध्ये बोलायचं.
मी मराठीत बोलतो.
हां, थँक्यू सर. सर म्हणजे आपल्या इथं खूप सारं प्राचीन ज्ञान आहे, हे आहे, त्याच्यावर म्हणजे खूप सारे मेडिसिन्स असतात, हे असतात. आणि गावाकडे कसं असतं, एक्झाम्पल तुम्हाला काय आजार झालेला आहे आणि गावाकडल्या वेगवेगळ्या व्यक्ती असतात ते नीट करतात ते, आणि त्यांच्याकडे खूप सारे रेमेडीज असतात, आणि त्यामधल्यात म्हणजे ते पैसेही काहीच घेत नाही, तुमचा आजार नीट करतात. आणि हा पैसा घेणं हे पाप समजलं जातं. हां, परंतु त्या ज्ञानाचा वापर करून वेगवेगळ्या मोठ्या मोठ्या मल्टीनॅशनल कंपनीज, फार्मास्युटिकल मोठे त्याच्यावरून ते औषध तयार करतात, त्याचं पेटंट तयार करतात. आणि खूप सारे म्हणजे ते फेमस होतात, त्याची म्हणजे किंमत अशी करतात की बस. आणि हां, मग ते ज्ञानाचा म्हणजे ज्ञान तर आमचं आहे, ते गैरवापर ते करावं असं म्हणलं सर. हां, आणि समाजाचं ज्ञान आहे.
Who is responsible for that? आपण रिस्पॉन्सिबल आहोत त्याला. का असं होतं?
परत सोसायटीचं ज्ञान आहे,
बरोबर आहे,
आणि सोसायटीच्या उपयोगासाठी परत त्या माणसाची जी ग्रीड आहे त्या कंपन्यांची, सोसायटीसाठी हार्म करायला, मग सोसायटीवर सॉरी त्या कंपन्यांवर काहीतरी असणार रिस्ट्रिक्शन्स.
See, the intellectual property rights are meant for the society. They are not meant for the trading community. By intellectual property rights, incentive is given to the inventor or to the copyright owner or to the trademark owner. Incentive is given to ensure that the public interest is protected. Therefore, each act has a time limit. Patent is for a fixed duration. Once the patent expires, it's in the public domain. Anybody and everybody is entitled to use that information. Same with copyright. There are time limits. For example, literary work, life of the author plus 60, because his legal heirs will be benefited, and thereafter the work will be given to the society for free or free of cost. That's the purpose of intellectual property. Now, when you talk about the traditional knowledge in India, it may be medicine, it can be about the food, it can be your daily habits, it can be your diet routine. All this has existed in our country for centuries, you can say. That is part of our social structure, that is part of our communal structure. We know in which geographical area, which is the local medicine available and for what purpose. Unfortunate part is that it is nowhere recorded. So after the implementation of TRIPS, you must have read somewhere or you must have heard that US got patent of turmeric, right? That is something, it's a misconception. One inventor in the US invented something by using turmeric. It was a medicine. It was patented. The reason it was patented is that the examiner who examined the patent claims, he did not have database that in India for centuries turmeric is used as antibiotic. It's a first aid in any rural area or any exactly. That was not known to the examiner who examined the patents, because his database which he searched did not contain this kind of information. So that is our mistake, because we did not convey this to the world, and therefore that patent was granted. Subsequently it was revoked. But that's the reason. If we give this information in a database to everybody, so all over the world, for example, the PCT application, application for patenting under patent cooperative treaty is getting processed through WIPO, and WIPO has this information about our traditional knowledge, about whatever, food or medicine. That application will be curtailed, that claim will be curtailed there. So that is something that we should do. Now you must have experienced that in rural area, there is a person who has medicine for a particular ailment, but he will never tell you what the medicine is. That is always kept secret.
परंतु ते सेवा देतात, त्या मोबदला ते पैसेही घेत नाही.
बरोबर, पैसे घेत नाही, पण ते काय नॉलेज आहे, दॅट नॉलेज
ते नॉलेज बाबा त्याचं अप्लाय करायचं, आणखी म्हणजे ते आहे मेडिसिन, पण त्या मेडिसिनचं म्हणजे त्या पेशंटवर वापर कसा करायचा ते त्यांना स्किल आहे, पण त्या मेडिसिनचा वापर असं कोणीही करू शकत नाही असं.
एक्झॅक्टली. पण ते तो माणूस ज्यावेळी अस्तित्वात नसणार त्यावेळी त्या ज्ञानाचं काय होतं,
नाही सांगितलं जातं दुसऱ्यांना, ट्रान्सफर केलं जातं त्या मुलांना किंवा कोणा मुलींना,
पण ते त्याच फॉर्म मध्ये येतं असं नाही.
ते स्किल
त्या माणसाचं औषध काम करते, दुसऱ्याचं करतच असं नाही.
तेही आहे, तेच औषध दुसऱ्याने केलं तर.
But that information we will have to share. Unless we share that information, there is no way it can be regulated.
आय थिंक शेअर करायला पाहिजे, आणि गव्हर्नमेंटनंच त्याचं स्वतः पुढाकार त्याचं पेटंट हे केलं पाहिजे. आणि आणखी त्याच्यामध्ये पेटंटची जी 20 वर्ष ते जुन्या ह्याच्यानुसार ते कमी झालं पाहिजे, 10-5 वर्ष, म्हणजे त्यांना ज्ञानाचा वापर जास्तीत जास्त प्रसार होईल. कारण म्हणजे नवीन शोध कशासाठी लावत नंतर समाजाच्या कल्याणासाठी लावलं जाते ना. मग समाजाचं कल्याण त्या काळात, आणि बाबा शोध लावणाऱ्याला प्रोत्साहन द्यावं, आणखी त्यांना नवीन नवीन शोध लावा म्हणून, आणि त्याला म्हणजे ते पेटंट राईट दिले जातात. म्हणजे त्यामुळे त्याला आणखी रिस्क त्याला पैसे भेटावे, आणि मागं त्या रिस्क त्यातून त्याला जे खर्चात तेही पैसे भेटावे. परंतु त्या काळानुसार 20 वर्षे इनफ होती, पण आता तो काळ कमी झाला पाहिजे असं वाटतं.
पण आता तो काळ कमी झाला पाहिजे, तर असं प्रत्येक इन्व्हेंटिव्ह स्टेपमध्ये असं नसतं की ते त्याला एक्सपेन्स नसतात. अशी बरीच मेडिसिन्स असतात की ज्याच्यामध्ये फार रिसर्चला एक्सपेन्स करायला लागतात, आणि त्याच्यातून सक्सेस मिळतोच असं नाही. सक्सेस एक दोन प्रॉडक्टवरनं मिळतो, 100 प्रॉडक्टमध्ये सक्सेस मिळत नाही. सो इफ यू काउंट दी ओव्हरऑल एक्सपेन्स, that expense is really huge. And it is not blanket protection which is given to the patentee. For example, 20 years tenure. In the Act, there is provision that government can grant compulsory license. So if the public interest requires, then the government can take out that patent and grant license at a cheaper rate. So the provision exists. These are not really blanket provisions.
आता एक्झाम्पल आपल्या करोनाच्या काळामध्ये जेव्हा मोठ्या मोठ्या कंपन्यांनी वेगवेगळ्या मेडिसिन तयार केले, पण ते त्यांचं म्हणजे फॉर्म्युला तयार केलं दुसऱ्या कंपन्यांना देण्यास गेले होते ते. आणि लार्ज एवढ्या मोठ्या म्हणजे सर्वांचं म्हणजे मेडिसिन दिलं तर सर्वांचं कल्याण झालं. परत ते त्यांचं म्हणजे आम्ही इन्व्हेन्शन केलं, ही केलं, आणि त्याच्यावर करोडो अर्ब खर्च केलेलं. आम्ही मग असं कमी पैसे त्यांना कसं द्यावं. त्यांनी मेडिसिन खूप म्हणजे महाग केलं आहे. कारण ज्याचं म्हणजे मनुष्य जाते बाबा त्याच्यावर एवढं मोठं संकट आलं, तुम्ही त्यातून पैसे कमावायला बघते त्या मोठ्या मोठ्या कंपन्या किती. आणि आपले बिल गेट्स म्हणतात की बाबा हा वेळ आला त्यांनीच कमावला, त्यांना आपण थोडे पैसे कमवूया. तर बाहेर संपायला इकडे कमी आपली
Honorable Professor in charge, Dr. Kavita Heda, ma'am, to kindly present her with a token of her appreciation.
I would now like to call upon the General Secretary of the Student Council, Ms. Kashish Arora, to deliver the vote of thanks.
Greetings everyone. As we conclude this lecture series, I want to express my sincere gratitude to each and every one of you for your active participation, insightful questions, unwavering engagement throughout this lecture series. I hope the knowledge you all gained here will be valuable in your future endeavors. The Chief Justice MC Chagla Memorial Lecture Series 2025 comprised a total of 4 lectures on the diverse topics and areas of law. The first lecture by Senior Advocate Mr. Chetan Kapadia Sir on the IBC, Rescuing Business and Recovering Debt, where Sir discussed the topic and the object of the code, that is to help the companies to resolve the insolvency and to keep the companies as a going concern, and also balancing the rights of creditors and corporate debtors. The second lecture by Advocate Mayur Khandeparkar Sir on the art of legal argumentation, where Sir dealt with the insights on the do's and don'ts of the legal argumentation. Third lecture by Senior Advocate Janak Dwarkadas Sir, which enlightened us on dynamics of corporate law and business transactions, which involved the basis of all the corporate laws that are there in the country, and the anecdotes given by Sir, which intrigued all of us equally. The last lecture, that is today, the fourth lecture by the Advocate Amit Jamsandekar Sir on the journey of trademark legislation in India, where the Sir provides us insights on how trademark law developed in India and how it is essential for the patents, trademarks, etc. Now, I would like to extend my gratitude to Justice Riyaz Chagla Sir and the MC Chagla Memorial Lecture Series, our Principal Ma'am Dr. Asmita Vaidya, our professors in charge, all the members of Student Council, volunteers, and to each and every one of you present here who have contributed to this event and with your presence. I, on the behalf of the Student Council of Government Law College Mumbai, is proud to announce the conclusion of the Chief Justice MC Chagla Memorial Lecture Series 2025. Thank you so much everyone for all your efforts.
Thank you everyone. Now I kindly request you all to
Thank you.